Hi, I'm Mitzi Hill. I'm a partner with Taylor English Duma in Atlanta, and I am the head of our data privacy and security practice. And as part of my work here, I work with companies on their privacy compliance obligations and information security planning that may be driven by privacy compliance. I have been doing similar work with companies for nearly 30 years as a technology lawyer. We're going to be producing a series of videos about the most exciting topic, which is state-level privacy laws. These are a new development, relatively new development, having sprung up in the last 5 or 6 years in the United States. And we are going to begin by talking about California's state privacy law, because it was the first and it remains the gold standard for the US. And we will then talk about the laws that have taken effect or are imminently taking effect in other states, or that have been passed by other states and will take effect in the next couple of years. California, in addition to being the first, has enacted one of the most comprehensive privacy laws in the United States. It's generally a consumer-friendly jurisdiction, and its privacy law reflects its overall philosophy and leanings as a consumer-friendly jurisdiction. I mentioned it was the first of its kind in the US. It was modeled on very similar legislation in the European Union, which is extremely consumer-friendly and in fact more consumer-friendly than California, and changes the paradigm of how companies have to think about the data that they collect from individual consumers. Prior to the institution of the California law in the United States, companies here were relatively free to collect data from consumers and use it in any fashion they wanted, with fairly minimal notice to consumers, and consumers really didn't have any rights in that data at all. The California law set the bar rolling in the United States on privacy considerations and privacy regulation. And what it did was institute a scheme under which consumers have rights in their information. They are allowed to access it, correct it, delete it, opt out of profiling of them for marketing decisions and sale of their personal data. They have the right to opt into processing of their sensitive personal data, and opt out of any automated or kind of algorithmic behind the scenes decision making about how to target them with ads, for example. And companies that are covered by the law for the first time have to give extremely explicit notice. They must give it before they collect any information from the consumer. So giving it to them after the fact is not adequate under California law. They are required under certain circumstances to perform internal risk assessments about how their data collection activities might affect consumers and adjust accordingly. And there are some data minimization requirements that apply to companies that are interacting with California consumers now, meaning they're not allowed to just collect data willy-nilly. What they collect must be related to the actual services that they're performing, and they should not be collecting more information than is necessary to perform those services. The California law remains unique even among the states that have considered or have enacted privacy legislation. For one thing, it remains the first, and it is still the standard setter. They started the privacy revolution in the states, and several other states have followed suit. There are some other things about California's law that set it apart from other states' privacy laws. For one thing, the second act of California's privacy revolution was to create a separate state agency that has nothing to do except enforce the privacy law. In most states, the Attorney General is the enforcer of the state privacy law, and it's just one more job that the Attorney General in their office has to do. In California, the Attorney General used to be the enforcer, but there is now an entirely new consumer protection agency, privacy protection agency, whose sole job it is to enforce the California law. And finally, California is, I think, still completely unique among the states that have either enacted or considered a privacy law, in that under certain circumstances, consumers can sue a company directly for a violation of the privacy law. In most states, all of that work is reserved to whoever the state agency is that enforces the law, be it the Attorney General or another one. California has chosen to take a fairly aggressive route with its privacy law in connection with both HR type data and business to business or B2B type data. Many state laws do not cover that kind of information because they consider that companies need to process that sort of data in order to conduct their business. And so they remain unregulated in use of HR and B2B type contact data. California started out that way, but after about a year, the law was changed so that it explicitly applies to both employee data, which would cover contractor data and employee data and job applicant data as well. So really anything that is HR oriented, and it applies to B2B contact data. So companies that are covered by the California law have to think about not only how they interact with consumers and how they treat consumers in respect of their personal data, but they have to give all of those same considerations to employee or HR type data and to B2B contact data that might be in their email systems or their CRM systems or similar, and certainly in their HRIS system. Under California's law, companies can face different kinds of liability. The state regulator that has the authority to enforce the law can impose fines on companies that are found to have violated the law. Those fines can range from $2,500 to $7,500 per incident, depending on whether the regulator feels like the violation was willful. So you can imagine that if your website were collecting data from thousands of consumers or millions of consumers and you were being fined $2,500 per or $7,500 per, it could add up pretty quickly. The other penalty aspect of California's law that is especially notable is that under certain circumstances following a data breach, consumers have the right to institute a direct action against the company for damages that they do not have to prove that they were damaged. They are allowed to claim what's called statutory damages, meaning the statute just assigns a value and allows consumers to recover. And again, based on the values assigned in the statute, if you had a class action of affected California consumers suing you after a data breach, the numbers could add up very quickly. There are defenses to those kinds of direct actions, and they generally have to do with the kinds of security and IT practices that a company employs behind the scenes. And so there are some best practices that are often recommended as a hedge against being hit with those kinds of allegations. In terms of enforcement, California came out of the gate strong. In the early days, the Attorney General of the state had the exclusive authority to enforce the privacy law. And while it had that authority, it went after several companies and instituted fines, even in the millions of dollars, against them. Some of the actions that they went after were things involving inadequate privacy notices, defective opt-out mechanisms, failure to give consumers adequate opportunity to exercise their rights, like asking for the information that they're entitled to access or delete, sharing information unlawfully with analytics or advertising services providers. This was sort of a sampling of the things that the Attorney General went after. Today, the law will be enforced by a separate body called the CCPA. That is the new privacy watchdog in California.